Your patent sucks. How to determine if your patent is actually being infringed. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. If you like this content, please like, follow, and share. If you're going to get into the patent game, it would really behoove you to understand the basic rule of patent infringement. Otherwise, you will tear your hair out running around thinking that everybody is infringing your patent, only to find out that they're not. The infringement analysis is a very specific formula, and it is not, does that look like my product? It is not, does that have the same basic principle of my invention? That's not the test. The test is a formal legal test. It's based on the claims. The claims are there, like I said in earlier videos, to define the scope of the invention. The only way you infringe a patent is if you practice every single element of at least one independent claim in the patent. That's the rule. It's called the all elements rule. I say independent because the independent claims are the broadest claims in the patent. If you don't infringe, or if somebody doesn't infringe any of the independent claims, they cannot, as a matter of logic and law, infringe the patent, because the dependent claims are narrower in scope and require everything that they expressly state, as well as everything that's in the claims to which they refer. So when I'm looking at an infringement issue, the first thing I do is I look at the independent claims and I compare them to the product. And if I can clearly see that the product is missing something that's in each one of those independent claims, might not be the same thing, but if I look at each independent claim and there's at least one thing in that claim that's not in that accused product, it's not infringing. Now, there is a nuance that concerns a doctrine of equivalence. I'm not going to go into that in this video. I'm just trying to stick to the basic rule called the all elements rule. So what I'm going to do to illustrate this is I made up a very simple patent claim for a stool, and I'm going to show you a claim chart. Claim charts are the mechanism that we typically use to illustrate a claim of infringement, because what we do is we line up the elements of the claim next to some image or some evidence of the product, and then we point to where in the image or the evidence that claimed feature is demonstrated. So let's take a look at this simple claim for a stool. So this is a fake patent claim that I'm using to explain how you look at a claim and determine if it's infringed. The rule for infringement is called the all elements rule, and it means that every element of the claim must be in the accused product for it to infringe. Now there's a nuance called literal infringement versus equivalent infringement, but I'm not going to get into that in this video. I want to keep this simple. So just for purposes of looking at whether there's infringement, you have to infringe at least one claim of a patent. The broadest claims will always be the independent claims by definition. So that means the rule is that you infringe a patent if you infringe at least one independent claim. You may infringe more, often you do, but the bare minimum to infringe a patent is you have to infringe at least one independent claim of the patent. And again, an independent claim is a claim that does not refer back to another claim. So this claim says we have a stool comprising a disc-shaped seat having a radial direction and an axial direction, and an upper surface and a lower surface spaced apart from one another along the axial direction. So if we look at this product on the right, we do have that disc-shaped seat with the upper surface, lower surface, and they're spaced apart along the axial direction. The next element of the claim is a plurality of legs, wherein each leg in the plurality of legs is attached to the lower surface of the seat and spaced apart from the other legs in the plurality of legs, and each leg in the plurality of legs projects away from the seat along the axial direction. And if you look at the diagram, you can see that that limitation is met as well. So in this particular case, that object would infringe this claim. Okay, so as I said in the earlier video, your patent rights will never be bigger than what's novel and not obvious about your invention. And what's novel and not obvious about your invention is what is in the claims. At the broadest level, it's what's in the independent claims. And I can't tell you how many clients I've had that have this disconnect between the arguments they made to get their patent allowed and what their real novelty is, and then what they think their rights are when they start to see competitive products. And sometimes they get upset. And I'm like, listen, that's not the scope of your patent. You didn't, a lot of times you didn't invent something that broad. There was prior art you had to distinguish. And if you can keep that in mind when you're starting the process, you will save so much time and energy and despair, quite honestly, if you understand that about the process and you don't engage in that disconnect or cognitive dissonance or whatever you want to call it. Okay? So that's patent infringement. I hope that helps to keep you out of trouble, and I hope to see you here soon.